Federal High Court in Abuja has rejected a motion seeking to restrain the National Assembly from approving budgets and appointments submitted by Rivers State Sole Administrator Vice Admiral Ibok-Ete Ibas, retired. Justice James Omotosho ruled that the relief sought was irrelevant as the Senate had already passed the Rivers State budget on June 25, making the action a fait accompli. The court also noted that the issues raised overlapped with a pending substantive suit. The case was initiated by several Rivers indigents and the Hope Africa Foundation, who alleged constitutional violations in the approval process, including the use of a voice vote during emergency rule declaration. They argued that such actions violated their rights to be governed by an elected administration and requested an injunction to halt further legislative approvals. In opposition, the National Assembly and its clerk maintained that the plaintiffs' claims were fabricated and their actions adhered to constitutional provisions. They warned that granting the injunction could create chaos in state governance. Justice Omotosho declined the motion and adjourned the hearing on the main suit to October 20, 2025. What do you make of this story, Ugochukwu?
Laurentia, it is really disheartening. It is really unpatriotic for some citizens of Rivers State, though it's well within their rights to seek court relief or interpretation in what they don't understand going on. But in the case that is in connection with the declaration of state of emergency, the coming of Ibas, and where we have found ourselves in Rivers State, which we brought upon ourselves, because we had ample time to really nick it in the bud, to bring about peace and close ranks. But we decided to go our separate ways in support for and against. That's what brought us to where we are today. I still see it as an unpatriotic move by some Rivers indigents to go to court to stop appropriation, the appropriation bill from being taken into effect. Because if it's about the passage is done and dusted. What they have gone there now is to stop the implementation. Who benefits from the implementation of the budget is a question they should have asked themselves. And of what gain and of what good will it be to the citizens of Rivers State? You were here last month when I cried, and I also said, even in churches, because Nigerians are quick to attribute their ill fate to one juju or the devil. But when I understood the body language of people in our church and in some forums I found myself, I quickly told them that whatever you're passing through in Rivers State now, near Port Harcourt, is as a result of we don't have a working budget. So any little business, any little thing you're doing and something is coming in, just be patient a bit. Because government is the highest spender, whether we like it or yes. Because civil servants are not receiving their pay as at when due. Contracts has been stopped in Rivers State. You saw even some people allege that Julius Beja went and blocked a particular road, and also villagers went and blocked some particular road because work is not going on and the contractors are not paid. So the pensioners are crying. And I also took something out from the budget Ibas proposed, where he captured a 50 billion whooping sum for retirees and pensioners. And I said that is his own constituency. Because we have seen Nyesom Wike come and go, took care of his constituency with the judiciary. We saw the suspended governor also treating his own constituency, the civil service, very well. And the bus has come and remember the retirees. That's where he belongs. So for them to go and want to stop it, that not taking into account what people are passing through in Rivers State now, I think is a disservice to the Rivers people. And kudos to Justice Omotosho, who has taken the bull by the horn to deny them their relief. And for them to even recall that the passage or the giving their backing to the state of emergency by the National Assembly is unconstitutional. And I asked the question, was the Constitution so explicit on the way the National Assembly should vote in such a situation? It was not explicitly. Even the House rule does not specify it. So who is somebody that is an meddlesome interloper in such an environment or in such a gathering, or how now begin to dictate the pace of how the National Assembly should go about their legislative duties? So we have gone past it. I said we brought it upon ourselves, and for the fact that the courts have not had whether it was right or wrong for Mr. President to have declared state of emergency and removed a sitting governor. Those cases have not been had. So any other case that is coming, that is attached to the declaration of state of emergency and how the sole administrator should carry out his activities, is just wasting judicial time and also wasting the person's time. And for the fact that, yes, is wasting the time, because if you have had the case instituted by PDP governors, or the cases that have been instituted by some CSOs in Rivers State about the constitutional right of Mr. President to have declared the state of emergency, if you have had it, those other adjoining substantive cases would have been, would have been entertained by the courts, or even before you go to court, you now have a background of where to anchor your prayers upon. But this one, we are left at sea. And for the fact that Mr. President has cited the constitutionality of the backing he got to declare the state of emergency, and also gazetted it, and backed by the National Assembly. So where are all those frivolities in our thinking coming from?
Say to a large extent, there have been concerns prior to this time. There have been concerns around voice votes, using voice votes in the National Assembly.
Yes.
I mean, it's not severally we've seen it come to play where, granted, voice vote is an acceptable way of voting in the House. It is acceptable. It has been used over the years. However, as things evolve, people will demand more accountability and more transparency, particularly when we have seen over time where probably something is called to vote in the House, and you have the nays and the ayes, and you can hear that
the nays,
at this point the nays are louder.
Yes.
However, the speaker or the president will give it to the aides.
That has a more tinier voice.
It is clear. It is visible to the blind and audible to the deaf.
Yes.
That at this point in time, that the nays were louder, way louder.
Yes.
But surprisingly, by some strange fates, the Senate president or the presiding officer in that particular plenary will give it to the faction with a much more smaller voice, which is the aides. It has happened over and over. And now you'll be watching and you'll be like, what just happened? So one would say, for the sake of transparency, for the sake of accountability, so that we know that this is what it is, the voting should be made electronic. And it should be transparent. I think to a large extent that I would be interested to know when a matter comes up in the House, what my representative, what did he vote?
Lies.
Yes. Did he speak
for or against?
For us, or did he speak against us? Did he, subdue his interest and let the interest of his constituents speak? I would want to know. I am sure Nigerians will want to know.
Of course.
What exactly are our representatives doing there? So when there are calls for that voice vote system to be scrapped, I don't think it's a call that should be swept under the carpet. What do you think? Apart from this emergency rule situation. I think, to a large extent, Nigerians have shown that concern. It has been raised.
I will elaborate on that, but where we are is about the event, according to Omotosho and the court. The court said the event they sought for, the action they want the court to take has been concluded. Remember that they also raised the issue of voice vote. I know.
By the National Assembly when declaring state of emergency.
But that particular act is leaning towards the concluded and the foregone activity that happened in support of the state of emergency. So also the passage of the budget has been done and dusted, approved by the National Assembly. Again, the third thing that is also done and dusted, which they sought there, is about that there is controversy about the constitutional powers of Mr. President to have declared state of emergency. These are the three prominent things that they sought. But having brought it, the first one, which has not been concluded and not had, which is still in contention, is about the powers of Mr. President to have declared the state of emergency and removed a sitting governor unilaterally. So that one is why the learned judge is saying that what they are seeking for is in a substantive case that is still pending.
I heard all that. You've said all that.
Yes.
Where I am looking at, I am not looking at the actions of the president right now. I am not looking at. I am looking at. I am picking the part of the voice vote, and I am not looking at it from the angle of River State emergency declaration.
Yes,
I am looking at it holistically. Is this not a right call in the right direction?
This is a right call and is overdue. It is well overdue in our democratic setting. But you know the kind of politics and the democracy we practice in Nigeria. Our practice has no name. Our democracy in Nigeria have no name. Our democracy is really a sham, so to say, to me. It's really a sham because it's neither here nor there. What the political allies are doing is what favors them. And the citizens, thank you that you even brought this concern to the fore because of its leg in the suit that has just been had. Over time, and they are saying they are doing constitutional amendments, have any of the citizens or any of the CSOs or CLOs written for the National Assembly's constitutional right to be rejigged, to capture it? It is not a house rule. We cannot get it right in that voice vote something by the amendment of the house rule. It has to go through the constitutional amendment. We have to, have those citizens that have it within their right to, write to the National Assembly and say, we want this section of the Constitution to be amended. Remember that when Ken Nnamani, when Ken Nnamani foiled the third term bid of President Olusegun Obasanjo X, it was through voice vote. And I have also stated on this fora that there was a letter that Ken Nnamani read on the day of the colloquium being held on behalf of the Pan Yoruba leader who is Abraham Adesanya. He said that he rode in the midnight to his house. He took himself to him and handed him a letter and said, to save Nigeria is in your hands. Because they have seen that Obasanjo has done all the calculations and all the underground work to make sure that he had his way. But at the end of the day, it beheld on the Senate president to use his staff of authority and say that that particular proposal will not see the light of the day. So, and that is what all the senior presidents have been leveraging on, because immediately they stamp it, it means that either the yes or the no, they have it. So, but now Hence, we are seeing that it is constituting a legislative, how do I put it? It is constituting a legislative nuisance. And the citizens are no longer happy with what is happening and the way they are abusing that usage, that particular privilege that have been accorded them. Then this is the right time for we to channel it instead of people. Laurentia, we are here now breaking our heads. You see, a lot of people will not regard this one. What they will be doing is now everybody wants creation of new state. We are not even talking about holding the National Assembly accountable to amend the Electoral Act that will favor you and I, that will favor the majority of Nigerians, so that our voices will be heard at the end of the day, having seen the lapses that existed in the last general election and the outcome from the courts. And the Nigerians will not write a petition demanding for the technicalities to be removed from in our judicial system. But we are there. Look at the section 305 that is not explicit on what the powers of Mr. President is. Nobody is questioning it. Nobody is writing to the National Assembly to look at that particular thing. These are some of the things that are inherent in us for us to know exactly where our rights are and how limited they are. Nobody is talking about it. Everybody is clamoring for state creation. It is very, very unfortunate that the things that concerns us as a people, we don't expend a lot of energy in it. Look at this particular one now that is really is really meant for us to know where the people that are representing us, because we see it in the UK, we see it in America, where people, their representatives will stand up and say their mind. Then the constituents will say, is he leaning into the public opinion or he's sentimental to the powers that be? Because believe me or not, when a discourse is tabled, we have opinions. We have the court of public opinion. We have even the one that the dissenting opinions we have. The majority and the minority, we have their say and their way. But what is the fundamental? Right. What are the takeaways? That is what we are. So what I will say here is that those who have to echo what the question you have asked me here should take it upon themselves and echo it and make sure that the National Assembly factors it into this constitutional amendment that that is going on now.
All right, very well. It's important to note, you know, when you were speaking, you said that voice vote is via the Constitution and not a rule of the House. Actually, yes. Order 72. Okay. Order 72 of the Senate rule book says that the mode of voting shall be one through voice votes, number 2, through signing of register in the division, yes. And then 3, through electronic voting.
Which they have not instituted.
No, they have.
Okay.
Now, in 2016, 2017, the Senate voted through electronic voting for confirmation of Supreme Court appointeis and amendment of the country's constitution.
So it's even in existence?
So it's in existence, and it has been used twice. In 2016 and in 2017. And after that, voice vote, electronic voting has
gone into comatose.
Used again. It has always been voice vote. But the argument would be that voice vote makes things faster and gives room for the Senate to deal. No, give room for the Senate to handle other legislative business because they are able to just quickly wrap this up and move to the next business of the day. However, electronic voting may take more time. But even though at this point it is needed in the country because of the trust deficit between the representatives and the constituents, between Nigeria and the Senate or the National Assembly, both House of Reps and Senate as it were. So Nigerians are interested to know what is going on in the Senate, in the National Assembly, what our representatives are doing and what their stands are in burning issues that affects us directly.
And Laurentia, even if it's not about the time consuming, but because of the exigency and the public importance that is attached to that particular state of emergency. Yes, a lot of, so they should have used it because this particular state of emergency was brought about a lot of confusion. It was controversial. So in order to clear the doubts, and remember that even before that, it has been alleged that the members of the National Assembly have been bribed. So those allegations and those fears and those ill feelings of Nigerians could have been alleged if they had gone through that voting. And also because of the way the state of emergency was contracted in the first place, knowing that we have not gone through that route. We have not gone through that route because Rivers State was not at war. Rivers State was not experiencing any insurrection. Rivers State was not experiencing any, what do you call it, external aggression from maybe Nigeria.
But according to 305, section 305, I think that H or, yeah, I think that I or H, there was an imminent threat
that is what
to breakdown of law and order.
I was getting there. Yes, I was getting there. But what I'm saying is that the ones that are very obvious to us, that maybe when you declare an emergency, people will accept it. But given the peculiarity of the Rivers State crisis, which is anchored on political crisis, political misunderstanding, it is very, very different from what the Constitution spelled out. So it would have been germane. It would have doused a lot of tensions if and it would have spelled out a lot of clarity if the Senate had gone through electronic voting, or if they have gone through, you know, all the senators, especially those from the south, to stand up and let them know their positions, so that the people will know those who are for and against, and know how to return them back to the house.
All right.
So that's my submission. But finally, I want to say that the civil society organizations should take it upon themselves and make sure that those rules of the Senate that have been lying fallow, that we see being undertaken in other Senate climes. When we call Senate climes now, they say that are we not educated in Nigeria? Sanity is not about education. It's about, you know, just like Obasanjo said, the Constitution is not the problem, but the implementation. So what we are dealing with now is the implementation of even the House rules, the rules they have for themselves. How often do they use it? Do they use it when it suits them, and they now bring it out when they will use it to witch hunt the other party? So to say.